All right. We
We're
are
back.
we are back.
Oh, uh, today's topic, plain smell. I was listening to a little Leonard Skinner Saturday Night Special. What a great song! I didn't tell Jason what the topic was until we just logged on
Yeah.
because I was kind of searching for something, and so I was going through my homework. Florida
Hey.
Law Week, and I found something pretty interesting that literally happened here in Hillsborough County. But before that, welcome back to another edition of Live Feed Read.
That's right.
I'm your host, Paul Reed, and the egg McMahon to my Johnny Carson, Jason Crawford,
Yep, yep.
appearing live from Tallahassee.
That's right.
And then, like I said, it's a plain smell. Jason, oftentimes we don't talk about what I'm going to talk about. This isn't a highly rehearsed show.
Okay.
Uh,
Oh boy.
this is what are we doing today? So, Jason, let's just play a game. When you heard what's the topic, plain smell, what did you think of?
I was uh I was thinking of cars and marijuana or
Oh, okay. Well, basically that's very close, if not uh, exact. It's an individual here in Tampa
oh,
that was on probation for crimes he committed back in the day.
okay.
And then jumping forward to 2023, if I'm not mistaken, this individual is in a passenger in a vehicle.
Okay.
The cops pulled him over for a license plate tag obscured and some other reason. Either way, they pulled him over, and as they approached the car, they smell what?
Ooh. The substance.
They smell marijuana.
Yeah, all right. Okay.
All right. Now,
Hmm.
mind you, marijuana has recently become legal in the state of Florida. All right. But back in the day, of course, marijuana was not legal.
Okay.
Therefore, if a police officer approached your vehicle and smelled marijuana, that was basically gave them a right to search your car and not violate the Fourth Amendment's right to unreasonable search and seizures because marijuana meant illegal activity. That was the short version of
Right.
all of that.
Okay.
Which if it's illegal, you smell marijuana. They called it the plain smell doctrine, and that gave them reason to basically probable cause to search your car.
Okay. Okay. So plain
Okay,
smell. All right. All right.
plain smell.
Okay.
All right. Well, of course, like I said, the law changed and now marijuana is legal. And so the question is the plain smell doctrine still give you probable cause to search the car as it relates to the Fourth Amendment prohibition
Mm.
against unreasonable search and seizure?
Ooh. That I think.
Okay. Well, hold
Okay.
on.
Okay.
So,
Okay. Okay.
hold on. We ain't
Yeah.
there yet, Johnny. So what happened was, like I said,
Sorry.
Mr. Williams is on here in Tampa is on probation. So he's a felon, and obviously, oh, he's a felon. You can be on probation for other things, but he was. But obviously, you can't, get arrested or commit crimes and so forth, or you'll violate your probation. Kind of simple stuff.
Right. Okay.
So the two officers come up to the back of the car. They smell marijuana, and so they ask them to step out of the car so they can search it.
Okay.
They searched the car. They found um, marijuana, of course, in the glove compartment, and
Okay.
some pills. And the pills, the individuals did not have prescriptions for them. All
Oh.
right. So they arrest the driver. They arrest the passenger, Mr. Williams, and they take Mr. Williams down there to the Pokey Orient Road. And when you get arrested, they search you to make sure you don't have guns and drugs and things of that nature.
Hmm.
Well, Mr. Williams actually in his sock had a little baggie with white powder in it. Yep.
Okay.
So they test the powder, and and he tells them it's Molly. Molly. There's
Yeah.
a term that I can't pronounce. Dementriol thought of beta pot. Oh, there you go. So anyway,
Yeah.
it's an illegal drug that
Right.
you can't have.
Yeah.
So then he goes before the judge, and the judge says, "Well, you violated your probation because you had Molly on your system." on your
person.
person,
Mm-hmm.
and that violates your probation. Well, he argues, well, wait a minute, whoa, back up there, Sparky.
Yeah. False start on the offense.
Yeah, exactly. He says, look, I'm filed a motion to suppress the search based on the fact that the plain smell doctrine is no longer justification for a search, given the fact that the laws have changed.
Okay.
Well, okay. Well, the fifth district in the Baxter case, but not the second district where we're at, had said, yes, the plain smell doctrine no longer is a reason to justify a search under the Fourth Amendment because marijuana is legal. You have to have some other indications that there may be criminal activity, and they called it the totality of the circumstances test.
Okay.
So they ditched the plain smell test for the totality of the circumstances, which could be, I smell marijuana, his eyes are red, blur, the same thing you'll get with alcohol. Slurred speech, et al, right?
Yeah. So they switched their initial
different test. Plain smell, marijuana is not legal. You could be doing something illegal. We're going to search your car to find marijuana.
Yeah.
Can't do that anymore in the fifth district, which is up in that Jacksonville area. But again, that doesn't apply to the state of Florida because each district at this particular point in time had their own test. The second district was still the plain smell. So Mr. Williams is saying, look, fifth district gets it. Plain smell is not enough anymore pursuant to the laws, the change in the law, right?
Okay.
Well, the judge don't buy it. He goes, well, in the second district, it's still plain smell. Have a nice day. Adios, muchacha.
Wow.
All right. Well, we ain't done yet.
Okay.
But at this point, do you have any questions?
Yeah, I mean, only that it's interesting because, in math, you're taught, as long as you get the right problem at the end, you got the right answer. Maybe you find out where your work went wrong, but at least you got the right answer in the end. And in circumstances like this, it's the opposite. It's more like logic. All of the things that come after are wrong if it's wrong here. So you've got to go back and fix the initial point of contact or the initial result.
And I think what Jason's saying that no one understands is if you start with the fact that the search was violated the Fourth Amendment, everything that happened after that is not, it should be, is undone. And so, all right, but so Mr. Williams appeals to the second district court of appeal, and the second district says, well, we kind of agree with our brother or sister state, or sister district, the fifth district. It says, and I'll read it, says, we agree that the legislative changes over the years to the definition and regulation of cannabis have eliminated the continuing validity of the plain smell doctrine.
Okay.
So right now, Mr. Williams, he's reading this and he's like, okay.
Yeah.
And they say, we accordingly hold meaning this is our ruling. When you say what's the holding, we accordingly hold that under the updated statutory text, the smell of cannabis standing alone is insufficient to establish probable cause to search that vehicle.
Okay.
In so doing, we recede from prior precedent. Okay. All right. So, and what we know that prior precedent, by way of example, that everybody knows is prior precedent was Roe versus Wade. The court a few years ago said we're receding from that precedent, and now Roe versus Wade is abortions are legal. Okay, so prior precedent is, well, it was this way, but things have changed. They've legalized marijuana, so we're ditching that, which is the plain smell, and we're bringing which they say we're going to go with the totality of the circumstances.
Okay.
All right. So, Jason, if you're Mr. Williams,
how
are you feeling right about now?
I personally wouldn't yet feel good, but I would feel
Okay.
like I've notched the door open.
Well, the reason you were arrested was the plain smell doctrine is
Yeah,
what they used for the search to find the drugs later in jail.
yeah,
And if the plain smell doctrine is held to be a reason not sufficient for the Fourth Amendment probable cause search, then everything that, like you said, that happens
hmm
after that has to go away,
yeah,
right?
yeah. My
All right.
only. Oh, sorry.
Go ahead. No,
I
go
was gonna
ahead.
say my only
The
concern
next
is,
question is, what happened to Mr. Williams?
yeah, it was a traffic stop with for a valid reason, and then they smelled that, but they could just as easily pivot to, oh well, we saw this or we saw something else that gave
Well,
us
that would be
probable
different.
cause.
That would be different.
Okay.
If you had like marijuana sitting in your seat,
Yeah.
well, that's not plain smell.
Right.
They could
Right.
say, "This is marijuana. Do you have a card?" And if you
Yeah.
whip out a card, thank you. Have a nice day.
Yeah. Yeah. Yeah.
If you don't, well, now you possess marijuana that you don't have a card for, and you go to jail.
Yeah. So that would be my concern with it. They would try to pivot to, well, we also saw something else. That's
Well,
why
they
we're
can.
really going.
That again, that would be the totality of the
Right.
circumstances.
Right.
If
Yeah.
they say, well, we saw a joint
Yeah.
sticking out of the ashtray,
Right.
like that. But let's just stick with the plain smell
Okay.
is not sufficient, at least in the fifth district and the second. This
Yes.
case is up before the Supreme Court of Florida to decide ultimately whether or not the plain smell is enough. It's probably not going to be.
Okay.
But either way, let's get
Good.
back to old Mr. Williams, who's
Yeah.
sitting
Let's
there.
find out.
His lawyer's reading this ruling.
Mm-hmm.
That's good. That's good.
That's good.
That's good.
But does
So,
it fix anything for him?
Jason, for $1 million on The Price is Right, what all happened to Mr. Williams? Did the second district say basically your rights were violated because they used the plain smell doctrine, and therefore that the molly they found after the fact at the jail should have been suppressed and all charges dropped, and you go your merry way? Or did they say something else that ultimately led to Mr. Williams' violation of probation, and back to jail he goes?
So I think, and I haven't read this, so I don't know, but I
Oh,
think
Jason has no idea
I
what
have
happened
no
to old
idea.
Mr. Williams.
But I think that they said that the judge had ruled, and at the time of the judge's ruling, that was still the case. But now we've rescinded it or receded it. So moving forward, it'll be this way. But when your case was decided, it was that way, and so you're screwed. That's what I think they're gonna say.
Well, okay. So here we go.
All right, let's
Is
find out.
Jason right? Is
No.
Jason the newest millionaire in Florida?
Oh no!
Let's see.
Let's find out.
However, as our precedent expressly permitted the search at the time it occurred, we affirmed the denial of suppression because in conducting law enforcement was acting in an objectively reasonable reliance on binding appellate precedents. Therefore, the revocation of probation stands.
I knew it. I knew it. I knew it,
So
man.
all of a sudden, Mr. Williams is feeling hallelujah,
Poor guy.
praise the Lord, to thank you and welcome back to prison. I know
Jeez.
that's a kicker. That was a tough one.
Why do they word it like that too? Is the approval of the we reject the approval of the denial? What did that say? What? It's so
Basically,
confusing.
they're saying that because at the time the police officers conducted the search,
Yeah.
the law in the second district
Yeah.
basically was plain smell was still the good law, that
Right.
you could search someone's vehicle under the plain smell doctrine,
Right.
and therefore the cops acted reasonably, and
Yeah.
therefore even though we're changing, like you said, we're changing it from this day forward, Mr.
Yeah.
Williams, you don't get the benefit of that.
So at that time,
decision.
then the motion to suppress is denied because it was still the standard.
Yes,
Got you. Okay. Ugh, poor guy.
but
Poor guy. He gets to watch the
No.
long line of other people who get to walk away from that situation, but not him.
my problem is Was it constitutional or not?
Ooh.
Not, well, because they thought it was constitutional back then. It was, but it isn't.
Yeah.
I
Is there a
mean,
fix for that? Is there a recourse for appeal?
United States Supreme Court, I mean, I'm sorry, the Florida Supreme Court
Hmm.
could ultimately take this Williams case
Hmm.
and say, well, we agree. They could say a couple things. We agree that it's the plain smell doctrine is not sufficient to probable cause to search the car. We're going with the totality of the
Hmm.
circumstances. But they could say, but that was the law when Mr. Williams, just like the second
Yeah.
district, that was
Yeah.
the law. Or they could say, no, even though this case or this issue had not been before the second district
Hmm.
yet, the fifth district in Baxter had held that the plain smell doctrine was no longer gave officers probable cause to search your car, and
Yeah.
therefore it was unconstitutional to use plain smell. And Mr. Williams, you're a free man.
So I guess one of the other things they're having to weigh is if they backdate any rulings, where do they stop? Right? Like, where do they stop backdating rulings
Well,
to update everything?
that's always the issue. And a lot of
Yeah.
times when the laws are made, it puts a start date.
Right. Yeah.
Like the statute of limitations for personal injury went from 4 years to 2 years, and it started October 24th of 2023.
Yeah.
So
Yeah.
all of those before that were 4 years. All of these were two. So the legislature tries to do things of that nature,
Yeah.
but this one was not of that nature. So Baxter, just so you'll know, all right. So that was a 2024 case.
Okay.
Uh, so let me see when the judge ruled on this one. This was a 23. So Baxter was even after this guy's, the totality of the circumstances. So either way, Mr. Williams,
Jeez.
the only thing he's got left is if
Mm.
the Supreme Court were to say that the law should have changed when marijuana became legal.
Got you. Yeah. Yeah. Yeah.
Yeah, yeah.
Ugh.
Uh, it's a very conservative Supreme Court.
There's a new case waiting for
If
you.
I'm Mr. Williams, I wouldn't hold my breath.
Yeah. Yeah.
If you think the United States Supreme Court is conservative, 6-3, six conservatives to three
Right.
liberals.
Right.
Yeah, Florida is 6-1.
Mm. 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 Mm.
Yeah, and
There it
it's
is.
Florida, and it's Florida.
Yeah. Yeah.
So I don't believe Mr. Williams is going anywhere anytime soon.
Yeah.
All
No.
right. So again, that's not even what I do. But when you read through these things, some things are interesting.
Yeah. Yeah. Yeah.
Some things you read that may help keep you, i.e., me, from going to jail. And not that I'm getting married anytime soon, but some of the family law stuff's important
Oh
to
yeah, it
know
is.
in case I met the my future wife, who I wouldn't hold my breath on that one.
Yeah.
But either way, I read other stuff, just
Yeah.
the personal, because it can be interesting. I saw this one. I actually had heard about it in the paper a couple of weeks ago, and when I'm going, I'm like, that's a pretty good one.
Yeah. No,
All
it
right.
is. It's really good.
So bottom line, but I will say this. In the Second District Court of Appeal, there was two dissenting judges, Judge Valente and Judge Ann Lee Gaylord Moe. Judge Moe, not a fan of. She was here in Hillsborough County, just not a fan of hers.
Okay.
Uh, Judge Valente, more moderate. I did appeal, and he was one of the judges on the panel, and he was pretty. He was fine. He didn't bust my. So either way, he was all right. Judge Moe, forget it. I don't even want to talk about her. But what he said is people who traverse our Florida highways are entitled to share the roads with sober and safe drivers. The majority interpretation of the law and wholesale erosion of well-developed, reasonable Fourth Amendment analysis will only undermine the evolved public expectation that law enforcement will continue to protect them as they motor along Florida highways. Got a point.
Yeah,
You know, you're out there driving around with your family and friends and kids, and you don't want a bunch of stoners out there.
sure. Yeah,
Yeah, yeah.
yeah.
So I mean, you know, it's that's just another side of it. And you know, the kicker is everybody that's listening to this in TV land, if you drive, you can smell that someone up there in front of you is smoking marijuana.
Yeah, certainly.
I mean,
Absolutely.
you're like, oh, I smell that. You
Yeah,
know, even
sometimes,
with freaking windows up and the air
yeah,
conditioner.
I was gonna say, sometimes it smells like one of those Cheech and Chong vehicles where it's
Yeah.
made out of marijuana itself. You're
Yeah.
just like,
So anyway,
wow.
that's a
Yeah.
legitimate argument.
Yeah,
Uh,
it's valid.
I'm not sure. And then he goes on to say, which is really the way to handle this. He says, I'm equally hopeful that the Florida legislature is aware of the dilemma that was inadvertently caused by the widespread acceptance of hemp and the legalization of medical marijuana. I invite the legislature to review this issue and to consider that its recent legislation legalizing cannabis for medical purposes has made it easier for nefarious individuals to engage in criminal activity.
Yeah.
I
Hmm.
believe what he's saying there is people with legitimate medical marijuana cards probably consume their marijuana at home for
Hmm.
their pain, discomfort,
Yeah.
nausea,
Right.
either once they're home for the evening. I think what he's saying the those individuals are not the ones out dr- not drinking and driving,
Hmm.
but smoking and driving
Right.
as the nefarious individuals who
Yeah.
probably don't have a marijuana card or even if, I don't know, but that's his point.
Yeah. And I haven't even,
It's a legitimate point,
yeah,
you know.
I haven't looked at the actual language in the statute, but if you're under the influence of something other than, sharp, keen mind for driving while you're
Yeah.
driving, I was driving down the road the other day and it just dawned on me as this big 18-wheeler just kind of comes past me on one of the roads up here in Tallahassee, and he's just like whoa, whoa,
Yeah.
whoa, 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 whoa. I'm like, man, these are massive machines. We're all driving around, and it's so wild to me. We don't run into each other more, but
Yeah.
certainly we don't want to be under the influence of something that makes that far more likely to happen. You know.
In the story. Yeah, it is. All right. Well,
Yeah.
anyway,
Yeah.
I thought that was an interesting topic. Even though, like I said, it's not what I do.
Yeah.
Uh, it was pretty interesting. You know, there's the Supreme Court up there, United States Supreme Court. Oh my Lord! If you haven't been keeping up with that, they're because October, the first Monday in October is when their sessions begin
Okay.
every year. They last, through, I don't know, January, February, whatever it is. But they just started hearing these cases, Voting Rights Act and the immigration and all
Yeah.
kinds of other things
Yeah.
that really don't make the news, so to speak, on things that they're
Mm-hmm.
ruling on. It doesn't feel good.
Yeah.
One of them was the Appalachian River is whether Georgia could cut off the water to Florida, and Florida's
Yeah.
like, what's going to kill our oysters, and that kind of stuff
Yeah.
that doesn't make the paper, at least doesn't make the social media headlines like these other things. But either way, it's interesting. You can go online to the Florida U.S. Supreme Court's website and read some of the things, and you'll at least understand why 6, 5, 4, or however many people rule the way they do,
Mm-hmm.
and why 3 or 4, 2 or 1 think otherwise.
Yeah.
And that way, you're not just listening to this stupid phone telling you
Yeah.
what they want you to hear.
Yep.
That would be my recommendation. And again, you'd be surprised that you will probably find it interesting.
Yeah, but we have to put our TikTok and cat videos down, Paul. What do you mean?
God bless America. All right, so here's the deal. Once again, it's Friday now, 1:26 on the 17th.
Yes.
If you got 1 hour on Saturday or Sunday, get your butt into church. Tell Jesus thank you for everything, because our Lord and Savior is the only reason we're here
Yep.
and doing well I don't care what anybody else says. It ain't gonna kill you. Bend a knee, say a prayer. You'd be surprised.
That's right. That's right.
Other than that, the Buccaneers are on Monday Night Football, which kind of stinks for Sunday because now I got to watch the red zone only and not look forward to my Buccaneers. But on
Yeah.
Monday night, then you're glad that they're on Monday night. But we're 5-1, kicking tail, and Jason's up in Tallahassee, and those
Yeah.
semi holes are
Yeah.
doing horrible.
Yes, they are. They are. But I'm paying
Yeah.
more closely attention to the committee meetings that are happening right now because that's where they're laying the groundwork for everything they're about to try to change this next
Yeah.
session. So, ooh,
Yep.
there's a lot.
Well, good luck, and take us out.
You got it. You got it.
I'm gonna get back to Leonard Skinner Saturday Night Special.
Reed and Reed, it's like having a lawyer in the family.